All right, let's go ahead and get started. It is 12 o'clock, and we are going to be moving through, making sure that we are getting through the listing agreement line by line. So I definitely want to make sure that you have a copy of it for sure. And then in addition to it, I'm also going to screen share. So you can absolutely be able to watch it from there as well. I just want to pull up Facebook here for a moment. That way, if we have any comments or anything that's there, I can answer those questions that you have. So this is a class for those of you that are curious about how to work through the exclusive right, the sale listing agreement for the state of Florida, right? So this document is one that has been written and reviewed by the Florida Association of Realtors and the Florida Bar Association. So keeping these things into consideration as you're walking through, making sure that you really take the time. You know, about 90% of the documents that we use have been written by attorneys and have been reviewed with our local association as well as our state and national association of realtors. It also is from that perspective that we don't have to be attorneys. As much as some of us like to use legalese language and do things like that, please understand that majority of what we do is fill in the blanks and answer questions that our clients have. So it's very important for you to know that that's really the direction that we go. I'm here to walk you through what that looks like, as well as to answer some best practices when you're going through and actually filling in the blanks. Okay, so we're going to get started. I am going to pull up my screen share here for a moment. Let me see if I can't get everything together. That way we can actually go through the listing agreement line by line. If you have one in front of you, go ahead and pull it, because that'll definitely be helpful. If not, don't worry. I'm going to have it pulled up here in just a second. All right. So right from the beginning, I want you to go ahead and look at the exclusive right of listing. Line 1, right, is letting them know that this is an agreement between two parties. So it's the seller and the broker. So with the seller's name, you're going to get this information from how it has been recorded publicly. If you are here in Pinellas County, you would go to the Pinellas County Property Appraiser's Office. You would do that online at something that is pcpao.org. That's Pinellas County Property Appraiser's Office.org. You can also Google with whatever respective county that you're in or that you're taking the listing in. You need to go in and see how was their name recorded. Sometimes it's recorded as first name, middle initial, last name. Sometimes it's recorded their full name. Sometimes it's just first and last name. Sometimes it's a trust. Sometimes it's multiple parties that people even forgot that they actually had someone on the deed. We have a situation where there's going to be a new listing, and they had forgotten that they had put their mother on the deed for that property. And so we came to a place where they were actually surprised that the two of them were not going to be sufficient enough for signatures. We would actually need a third signature, all parties that are there. So if you are writing on your listing agreement, then go ahead and put right here where it says seller as a reminder for you, PCPAO or Property Appraiser's Office. We definitely want to make sure that we're getting the right information about who your seller is. So that's number 1, or rather line 2. For line 3 is talking about your brokerage. So this is not your name. This is the name of your brokerage. So if you are in the downtown St. Pete office, then your brokerage name is Keller Williams Realty St. Pete. You please need to make sure, however the DBA, the doing business as, however your broker is doing business or the brokerage is doing business, it needs to be in that format. So please do not put KW. We are Keller Williams. We are not just KW. So whatever your brokerage name is, it needs to be exactly as it's listed in the multiple listing service and how it is defined with DBPR, the Department of Business and Professional Relations. So please make sure that for the line that says line 3, broker, that you're putting your brokerage name. Then we move into the authority to sell someone's property. And so this is the actual paragraph that is letting the seller know that the seller is giving the broker the exclusive right to sell the real estate and personal property, collectively known as property, on the real estate, because remember, in our business, we sell the land and all of the improvements thereon. And so it's going to be what is described below. At the price and terms described below, beginning today's date, right? The day that you are signing, the day that you are meeting, please do not post date your listing agreements. If you are saying, well, Michael, you know, we got to get photography and we have to do staging and we have to do this, that, and the other, well, then that's when you would do an extension, right? Which is that the owner's waiver of MLS entry. So when you go public with marketing and when you actually take the listing, those are two different dates. If I'm sitting down with someone and I'm going through the documentation with them, I also want to go to work with them immediately, go to work for them immediately. I want to start to be able to employ my photographer, my videographer. I want to start taking measurements. I want to start doing the activities that I need to do well before we even get to the place that we're going to be marketing it to the public. So the effective date that you start the listing agreement would be today's date or the day that you're meeting with them. Termination date. This is completely up to you and the seller for how long you want to do this. Now, for instance, if I'm selling a $3 million property and the average days on market for $3 million properties that are not on the water is in excess of 365 days, then I'm not going to do a listing agreement for 6 months, right? If the average days on market for that particular price point is, say, 30 days, I'm probably not also going to do a listing agreement for just 30 days, right? Because that's based on the average, that's not total. So pretty general rule of thumb is people typically do a 6-month or a year listing agreement. And you can do it for less than that time, more than that time. It's really about having a conversation with your seller. You know, I see some people that are here. So let's say that someone joins and we're having a conversation and I say, when would you like to move? They say, well, we'd like to be gone within the next 3 months. Okay, fantastic. Well, if I can put just a generic 6-month term, and yet our intention is absolutely to get your home sold and for you to be moved out within 3 months. Now, if they say, I really would feel more comfortable if we just did the listing agreement for 3 months, you can either A, have a conversation about what the termination language is, if they want to cancel the contract, which we're going to go over a little later today, or you can say, absolutely, let's go ahead and do it for 3 months. And then if you feel like I've done my job and all of the things that I possibly could, we just need a little bit more time in the market, we can do an extension. Please don't feel like this is a hard line of what your term of the agreement is. This is something for the two of you to have a conversation around the expectations for time. I personally love to use the listing agreement or the buyer brokerage agreement as a conversation starter. It's also a way for me to have checkpoints through the conversation. So I know that I get to have an opportunity to talk to them about the property that they're trying to sell. Are they going to be taking certain appliances? Are they going to be taking certain chandeliers or other things that they have in the home? It also allows me to talk about their time frame and how much they're wanting to get out of the home. All of that can be discovered by using this document, as opposed to having a really great conversation for an hour with someone, and then now you pull out this big legal document and you just expect them to sign right away because, you know, the two of you got off to a great start. It's really important that in my business, right, and of course you can do it however you want, in my business, that I really go through the listing agreement to answer those questions that they have, right? So your time frame is today's date or whenever you plan to start working, right? We do not post date. And then your termination date would be determined by you and the seller, whether it's 3 months, 1 month, 6 months, a year, whatever that looks like for you. All right, moving down, you will see that also I do want to have a conversation here for that second part that's there. That is that the seller and broker acknowledge that this agreement does not guarantee a sell, and that this property will be offered to any person without regard to race, color, religion, sex, handicap, familial status, national origin, or any other factor protected by federal, state, and local law. Seller certifies and represents that she, he, it is legally entitled to convey the property and all of the improvements, right? So it's from that perspective that you let them know, you cannot ask me, are the people who come into the house, are they Puerto Rican? Are they Black? Are they Hispanic? Are they Asian? We have had sellers absolutely in the past not want to sell their home to certain individuals. Can they do that? The answer is absolutely not. So we definitely want to set that up on the front end. I want to set it up on the front end because if someone is going to be persistent on that, I don't really want to work with them. And so again, it allows us to have a conversation around the actual listing agreement and the partnership that's there. More often than not, when you are signing a listing agreement, it's probably going to be with someone that you don't really know very well. It's probably the first time that you've actually sat down with them to ask them some critical questions about themselves and their business. And that's why it's so important that we do what we do here by using this form as an opportunity. So description of the property. So for the street address, again, I would prefer for you to be going into the street address from the public records, right? And of course, you're going to verify with them, but with the legal description that is in the public records as well as the street address that's in the public records, however it's filed there, is really what it should look like on the listing agreement. With that being said, I know that some people, you might take an expired listing, which means that it's one that was previously put on the MLS. And so some agents will be lazy. They will go to the previous listing and they'll just kind of copy and paste the information from the MLS. I also see this happen when people are working with buyers and they just use the information that's there on the MLS to go ahead and fill out the contract. Please do not do that, right? Human error is absolutely going to be there. The agent themselves could have accidentally put the wrong legal description on the MLS. I would much rather that if there is an error from the public records, right, the property appraiser's office, I would rather the clerical error be on them than it would be on the other agent or on myself. So please really be utilizing those local government public record resources that we have to help us answer these questions, right? In the personal property, including appliances, this is a really great conversation to be having with them. Oftentimes, before you actually go to the listing, you don't know what they plan to take or what they don't plan to take, and maybe they don't even know what they plan to take or don't plan to take. So this is an opportunity to ask them, are there any appliances that they intend to take with them? Whether it's the washer or the dryer. I had a listing where the wedding gift when they got married was this stainless steel refrigerator that my seller's mother purchased for them for their wedding. And her mother lives in Greece. And so it was a really big deal. And she was attached to this refrigerator. So it was very important for me to know what was conveying and what wasn't conveying so that I could then make sure that any buyers that were walking in actually knew what they were walking into. This is also a really great opportunity to have a conversation with the seller if they do plan to take anything. If they plan to take the chandelier, if they really love the custom ceiling fans that they put in, and so they're going to be taking those custom ceiling fans. This is a good opportunity to have a conversation with them that is, well, maybe you might want to go ahead and pull those things down or replace them before we photograph the home and before we show buyers the condition of the home. I had sellers that loved their ceiling fans and the contract said ceiling fans. And when we walked in, I was working with the buyer, when we walked in for the final walkthrough, right, the day before closing, we looked up and those original brushed metal and dark wood appliances, or rather ceiling fans, had been replaced with the original white cheapo ones that came with the house when they first bought it, that were kind of like your generic ones that the builder had included. That's a big deal, right? Because the contract itself says when you go through the walkthrough that the home is in the exact same condition that it was in when you had originally shown interest and you made an offer. So it's very important that you can have this conversation on the front end. Listen, if you want to take those things, let's go ahead and move them now. That way the buyer doesn't get attached to it. Whether it's a chandelier or it was your great-grandmother's, whatever that there might be. It's very important that as you walk through it, you really do take those things into consideration, right? So with this, we are able to put down the personal property. If you find that the personal property is too much for this line, that's where the see attachment button comes in. You could just check that box and then go ahead and have an attachment of all of the things that are listed. If there's a refrigerator in the garage, we need to know, are refrigerators, plural, included, or just the one? Are they planning to take a washer and dryer? Do they have a garbage disposal, right? When I'm walking through the house, I'm not necessarily opening up the cabinet and looking underneath the sink. I'm going to be having conversations. Is a garbage disposal included? Do they have a compactor? Like, what are some of the things that they're doing that can be helpful? So we really want to take them through and get a firm understanding. Line 19 is talking about occupancy. So is the property currently occupied by a tenant or not? So a tenant, right, is someone who is paying and has a lease. And so therefore they have tenancy rights. What's very important about this is if this is an income property and there is a tenant where it says if occupied, the lease term expires on when, go ahead and get a copy of the lease while you are there, right? Go ahead and ask for a lease so that you can have it. You'll be able to provide it over to the buyers. You'll be able to explain how long the lease is for. What are some of the rights that the tenant has based on this agreement? Is there an early termination or cancellation that can work for either party? And that's also helpful because guess what? Some people think that the lease expires in January, but they forgot that it actually expired in February. So don't just rest on someone's mindset. Really try to get a hold of that previous lease so that you feel comfortable and confident that they know what they're doing, right? So occupancy, whether or not the property is occupied by a tenant, we're going to check yes it is or yes it is not. And then we're going to get our lease, a copy of the lease so that we can have it. So now with price and terms, just so that you know, typically for me, I'm going to go through in this first page, pretty much everything's going to be filled out beforehand, except for the personal property because I don't know what all is going to be included. And then the price, right? And when we get into price, because it is really not our suggestion to tell them a price. Because what happens if you're wrong? What happens if the market is wrong? So making sure that you're positioning the way that you're pricing a home with a seller, you and the seller, you are now a team. You're going to take the information that you've gathered through comparative market analysis. You're going to take some information about what you know is going to be happening in the community. You're going to take those things and then you're now going to put that into a situation where you and the seller can make an informed decision. And then that's where we're going to be pricing the home. The reason why we also say this is because if you told them that their house was worth X and all of a sudden the market is not responding to X. So let's say that you told them that the house was worth 400,000 and it's not worth 400,000 and the market is telling you that no, we actually need to be closer to 375. Who gets to be the villain? Well, you do, because you told me that my house was worth 400,000. We have to be very, very careful about this, right? That's why when we make a decision together, we have an initial conversation, we make an informed decision, we both collectively agree on a price. And even though we agree on a price, we also are able to say something to them along the effects of, listen, I don't have a crystal ball. And yet we know that one of three things is going to happen. Number one is that we're going to have no showings, no offers, which means we're overpriced. Two, we're going to have multiple showings, still no offers, which means we're overpriced. Or three, we're going to price it just under market value, where we're going to have hopefully multiple showings, even multiple offers, possibly getting into a bidding situation. We do have a lot of contracts that are happening these days where there's a need for an escalation or people are paying over list price. And that means that we've priced the home just at or slightly below what the market will allow. Now, in today's day and age, we've got so much technology and research on our back end that we're going to be able to know whether or not our price is in alignment with what the market will allow, probably within the first 10 to 14 days. And so I just want to make sure that you know up front, as we're going through this listing agreement together, that I'm going to be having conversations with you weekly about the traction that we're getting online, the amount of showings that we're having, the response that we have at our open houses. and we might need to have a conversation about correcting that price. So break script, that is something that I would go through with my sellers to make sure that they feel comfortable and confident. And I'm also setting the expectation that if we do not receive an offer, this is what that's going to look like, right? So price, we're able to establish price. We're going to do that together. Now for financing terms. So financing terms, do not just check all of the boxes, right? If you're in our local area, right, if you're in the Pinellas area, the Hillsborough County area, someone who's here, whether you're online or you're here in Zoom, I guess you're all online, I guess I'm at Facebook or on Zoom, tell me what is the loan limit for an FHA loan? Go ahead and put that in the chat box for me. Okay, so probably something that would be good for you to research, especially if you are a licensed agent. So Kat Boshin said 470,000 with a question mark. Well, it depends, right? So when we talk about an FHA loan, there is an opportunity to do where it would be a single family home or it would be multifamily. If it is a single family home, and we'll just use that for the example here, last I checked, it was just over 300,000. It was like 309,000. And now, granted, it might have increased since then. So I would love for someone to fact check me and give us an updated on what that amount is. But let's just say that it's around 300,000, 309,000 for a single family with FHA. Well, if I have a home and we're thinking about pricing the home at 500,000, are we really going to be accepting an FHA loan? Probably not when an FHA loan is requiring just 3.5% down. The FHA loan is there to help someone who really doesn't have the same down payment capabilities like a conventional loan. Because of that, they also deal with some additional insurances and things that they need to do. And so we would not check the FHA box if it's not applicable. Kat said, thank you, Catherine, that she said that single family is 417,000. Now, is that for Pinellas County or is that just the highest somewhere in the country? That seems extremely high for a first-time home buyer or someone who's breaking into the market. Absolutely, Georgia. So Kat's going to clarify for me if that is a Pinellas County limit or if that's like San Francisco's limit. So when she does that, I'll bring that back. So this is a really great opportunity. You do need to be able to have that conversation. It's here. Okay, so it is here in Pinellas County that the limit for an FHA loan is 417,000. Okay, well, you learned something new. And apparently cheap isn't cheap anymore. Okay, so knowing that, you're going to have that conversation. Again, the point still holds true. If we're going to price a home at 500,000 and there is an FHA limit of 4. Yes, okay, thank you. She says that she was corrected. That is 317,000. That sounds a little bit better. Thank you. So again, no matter what, this is a really great conversation to have and explaining to them, because guess what? Some sellers have no idea. Some sellers have heard, well, I hear that with FHA loans and VA loans that it's really hard to pass appraisal. Okay, well, that's a myth. There is a different form that they have to use, but it doesn't necessarily mean that your appraisal is going to come in under every single time, or that you're going to have a whole bunch of repairs every single time. We don't speak in absolutes, so we absolutely want to let them know the difference of the different kinds of loans that they could be receiving. So cash, of course, is king, followed by conventional and FHA, and then followed by VA, and then followed by finally FHA. You want to be very careful about that. I do know that we're not there yet in terms of actual legal ramifications. However, last I heard that they were moving forward to make sure that a protected class would also be veterans in the future, because people have been discriminating against veterans by using a VA loan because of the story and narrative that I just told you. So it's a really great opportunity to just have a conversation with them. Now, another thing, we have some really interesting opportunities as well, not in the St. Pete proper area or even the city of Tampa proper area, but you do have in like South Hillsborough County, as well as parts of Manatee, that there were these areas that were rural that the USDA had identified as areas where they would want to be able to use the USDA financing loan. And the USDA financing loan actually goes up to 103% of financing. And so you will find that Lennar and other big builders have been building in these opportunity zones where these USDA loans are applicable. So if you find, even though it's new construction, even though it's in a master plan community, even though there's not 9 cows right next to the house, that it could still qualify in the zone of USDA. And so as a listing agent, it would be really great of you to know that, because you might be able to advertise this home differently. That is, that we can also potentially accept a USDA loan. So that would be where we would put the other, and we would specify if it was applicable to this particular listing. Line 24 is to have a conversation. Mr. and Mrs. Seller, do you intend to do any kind of seller financing, or do you want all of your cash out at once? Oh no, I want all my cash. Okay, well then it's not applicable. Line 26 would be an assumption of an existing mortgage. Most of your mortgages are not assumable, right? Sometimes a VA is the most common, would be a VA loan, because of people who get relocated, they get stationed, they get deployed. There are some situations that would be there. That would be probably the most common where you would see an assumption of an existing loan. But always, always, always check with your lender, especially with your seller, if they do in fact have an assumable mortgage, if that's what they're trying to do. Again, more often than not, especially if you have a lender, your lender wants to get paid in full if you're selling it, and you want as much equity. So the most common that we're going to have is that they're just looking for a full sale where they can get all of their money, right? Seller expenses on line 37. So seller expenses says that the seller will pay mortgage discount or other closing costs not to exceed a blank percentage of the purchase price, and any other expenses seller agrees to pay in connection with the transaction. So you can have this conversation on the front end, or you can have this conversation if it gets to that place of negotiations. But this is a great time to have a conversation with your seller. That is, very often, especially depending on where they are in their price point, very often buyers these days are making offers to where they're asking for the seller to contribute towards closing costs. And so then you can go in and actually explain what that means and how that affects their net, and what are some ways that they can either accept that or combat that if that's what they're looking to do. So you can have that conversation on the front end around what that looks like. Does anyone have any questions about the seller expenses portion or anything here in paragraph 3 before I move on? So Kelly asked the question, and I'm going to preface with, I know that this is on Facebook. I am not your broker of record, right? So I'm telling you some of best practices. I'm telling you what I would do. I would always say that you can defer, or should defer, especially if you're watching this and you're not with Keller Williams, you're not within our particular office. Always defer back to your broker of record on what they suggest. So we don't speak in comments, but I just want to say that. So Kelly asked, what's the typical percentage? Oftentimes you can have a closing where the seller is not paying any expenses towards the buyer's mortgage discount points or closing costs at all. You'll find typically that if someone is speaking to their lender, it depends on the loan. Some loans allow them to have up to 3%. Some of the loans allow them to have up to 6%. Seller concessions, or the seller to be able to pay some of those expenses. And so you will find that some people will say, you know, buyer and seller or buyer requests seller to contribute 3% of the purchase price towards buyer's closing costs, prepaids, and or allowables. Well, that's a request, right? And so this is not contract class, this is the listing agreement class. But you can let them know that it's very well possible that you're going to see that request from someone. And when we receive it, how would you like to move forward? Georgia said, should we encourage seller expenses? Well, that really kind of depends. It depends on what the seller is going to do. If it's advantageous, I don't necessarily would advise a client to or customer to just give away part of their net if it's not necessary, right? So it really is, the seller should do everything that they can to position the home in the best possible light. And then we cross that bridge when it comes to owner or seller expenses and what's to be paid in that regard when that time comes about. Oftentimes I can have a question or I can have a conversation with the buyer's agent, and I will ask, even though they don't necessarily need to tell me the answer at all, but most of them are forthcoming. I will say, you know, Georgia, thank you so much for your offer. I appreciate it. As I go to present this to my seller, it would give me a lot of clarity to ask you just a couple questions. One of which is, I see that your buyer's requesting 3% of the purchase price towards the buyer's closing costs to be paid by the seller. I'm curious, is that a want or a need? And then I shut up. And the agent on the other side will tell me one way or the other. They'll be like, oh, well, it's kind of a want. You know, they're doing this, that, or the other, blah, 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 blah. And it's from that perspective that is, if it is not like they cannot buy this house because they're putting every last dollar into the down payment and the closing costs and the home inspection, they're not going to have anything left over, then a conversation is to be had. Again, you know, my perspective is, why are they buying a house if they can't afford it? But I'm never going to say that directly to my seller. It's having a conversation around what that looks like. Yvette said, I just had a listing and the seller asked me if I brought them the buyer and the seller, if I could discount my commission to 5 from 6. How do I negotiate that question? Great question, Yvette. I will have that conversation when we move further down to the compensation. Just stay on me to make sure that I answer that for you. Not to mention that this is public on Facebook, so I can't collectively discuss commission. I can only do that within our brokerage, so I might have to take that offline. I will take that offline, Yvette, but I'll kind of talk about it in a general sense if I can dance politically, okay? Oh, I totally skipped past it. Okay, so broker obligations. It says that the broker agrees to make diligent and continued effort to sell the property until a sale contract is pending on the property. Now, this doesn't mean that you stop working. It just means that you are no longer marketing the home the same way that you were prior to getting it under contract. Now that we're under contract, we're in transaction management. We're also making sure that we're moving through all of the contingencies that have been set forth by the contract. So just letting them know that this paragraph is saying that we're going to do everything in our power to market the home. And even when we are under contract, we actually also encourage backup offers. And so that's just really saying the type of marketing effort that we're going to do. Part of that marketing effort is paragraph 5 that talks about the multiple listing service. So places the property on the multiple listing service is beneficial to the seller. It exposes the property to a large number of potential buyers. In addition to that, because we syndicate with the multiple listing service by being with Keller Williams, that then syndicates to more than 450 websites that people can go to. And now, as much as that's great that you're on, you know, Walmart.com and you're on GanderMountain.com, we really understand that it's going to be important about how we're marketing and messaging to those kind of top 5 websites. However, that is very helpful with the multiple listing service, number 1. Number 2 is that also by putting your property on the multiple listing service, that is where the brokerage community looks for homes. So if you're a for sale by owner and you post on Zillow, that's the only place where people are looking. And then you keep wondering why the only people who are calling you are agents. It's because agents that are calling to try to get for sale by owners are the only ones that are looking on Facebook for sale by owners, or Zillow for sale by owners. And so what's really important about this is to understand that about 89% of buyers actually use a broker during the home buying process. And so therefore, since brokers look on the MLS for listings, to not put your home on the MLS is almost a disservice to yourself and to your property, which is why it's so important that you get that added benefit when you list with me, when you list with Keller Williams, when you list with whomever, right? So letting them know what that does. It says that the seller authorizes the broker to report to the MLS this listing information and price and terms and financing information on any resulting sale for use by authorized board association members and MLS participants and subscribers, unless seller directs broker otherwise in writing. And we're going to kind of go a little bit further so that you can see what that looks like, right? So paragraph 6. Paragraph 6 is talking about the broker authority, right? If you remember, the reason that we're called agents from school is that instead of being a power of attorney, we are a special agent, or our brokerage can act as a special agent for the seller in one regard. And we actually function as a transaction broker, and so we'll have that conversation as well. But this is just saying the authority that the seller is granting the broker. So they allow us to advertise the property as the broker deems to be advisable, including advertising the property on the internet, unless limited to these two things. So the seller can opt out. So the seller can choose to display the property on the internet, but not use the street address. Or the seller does not authorize the broker to put it on the internet at all, which is, just shooting yourself in the foot. I do want to advise you that on line 55, you'll also notice that anytime that you see on the line numbers to the left of the document, you'll see a little asterisk. That's not on every single line. That asterisk is only where an action needs to be taken or something needs to look at. I always, because your compliance officer, Ms. Kat Boshin and Eve Zwicky, are going to send it back to you if you do not have line 55 initialed. So go ahead, since we are so used to initialing everything on the bottom of the page, go ahead and highlight line 55, just so that for me, I always think of it as it's kind of a stop sign. Before I can move on, I need to discuss this with the seller and just let them know what that looks like and why we should probably not check either of those boxes, right? Line 56 says that we're able to put out signage, right? We're able to put a sign in their front yard. We're going to let them know what that looks like, when the sign's going to be delivered, when the post is going to be delivered, and let them know that it's also, we are going to be using some of the things that are there to help market the home. Now you see here it says, and use seller's name in connection with marketing or advertising the property. Well, that might mean that I'm saying, hi, my name is Michael Reedy. I've actually been hired by the Smiths, your neighbors over at 123 Banana Street, and then go on with the rest of the script. You can do it that way, or think about if you have someone famous. And so you say, I'm selling Michael Jordan's house. This would say that I'm allowed to use the seller's name in order to do that. I'm going to obtain information relating to the present mortgages or mortgage of the property. And the reason that I'm going to do this is because it's going to help me go ahead and build out a net sheet for you, or a tentative net sheet based on the data that we have, so that you have an idea of kind of what you're going to walk away with after everything is all said and done, right? D, line 59 says to provide objective comparable market analysis information to potential buyers. So again, this is an opportunity where they can see how the home compares to the competition, why we are positioned as the best property for them to use or for them to buy, right? 60, this is where you're going to check the box if you intend to use a lockbox system. I use this as an opportunity to just trigger and remember so that I can tell them that we use an electronic lockbox. An electronic lockbox is one that the only people who can access it are individuals who are a part of the local association of realtors or affiliated with the realtor association. Their fingerprints are with the state of Florida, and so we're able to track who walks into a home, when they walk into a home, when they leave, all of those things, as opposed to just having a combo lockbox, where unfortunately there are some people in this industry that would just give that combination to a potential client so that they don't have to get in the car, they don't have to be there. This ensures that a licensed individual is going to be the only people that are going to be able to walk through the home, and we can keep track of it. So I say that information right here at line 60 because it's a really great reminder. I'm talking about lockboxes. I might as well talk to them about the expectation that's set there. Line 64, and please, don't get hung up if I don't read every single word, because I do only have 20 minutes left to be mindful of your time, and you can always go back and read all of these because it doesn't change or hasn't changed in a while. So looking at these things are helpful. Line 64, do you intend to withhold verbal offers, or do you intend to withhold all offers once the seller has accepted a sales contract for the property? You can do whatever you want. Again, I'm not your broker of record. That is, okay, thank you, Yvette. That is the information that's there for you. So going ahead and looking at this, when it comes to withholding a verbal offer, I let my clients know, for me personally, I do check that box. I don't check the second box, but I do check the box to withhold verbal offers, because verbal offers do not hold up in court. And since they don't hold up in court here in the state of Florida, I don't like surprises. The only surprises that I like are good surprises. And so to call my seller and say, hey, someone just called me. They said that they're making a full asking offer, that they're going to be sending the offer over in a couple hours. I get my sellers all excited. And then it's 9 o'clock at night. I still haven't received an offer. I text the agent. They don't text me back. I call the agent the next morning. They don't answer. I text them again. Hey, just checking in. Are you submitting the offer? And they go, yeah, so when they got home, they had dinner, they thought about it, and they want to keep looking. I'm so sorry. What have I done to my seller's emotions? I've kind of taken them all over the place in 24 hours. And so that's number one. Number two is there are so many pages to the contract that there are so many variables and different aspects that could make one offer stronger than another, that you can't just call me and tell me the purchase price and when you plan to close and think that that's enough of an offer. So I do withhold verbal offers until we receive it in writing, and then that's when I personally present it. You can do whatever you want. Line 65 just lets them know that we act as a transaction broker, right? So again, it's not about me as an individual, it's about my brokerage. So I let them know in my particular case that Rachel Sartain is my broker of record. Myself, as well as a little more than 260 other agents, hang our license and do business under the scope of our broker, Rachel Sartain. And so the transaction broker aspect allows for Rachel to potentially have an agent that would represent you, as well as an agent that might represent the buyers. We do, as an office as large as we are, and for being number one in all of South Pinellas, we do a lot of business with one another. There's someone else in my office who probably has the buyer for your property. And so this just says that it allows for Rachel, my broker, to be able to represent both sides of the party, or both parties rather. That's what that really helps us to do. Virtual office websites. So if you remember, or you think back, or there even some of them are still alive, the small brokerages that used to kind of pop up in the strip malls, and you would walk past their front door and you'd see all of the listings that they have would be taped to the window. Well, that was to let you know what the office had in terms of inventory. Well, something like Zillow or your own personal KW website or whatever it is that you're using is technically your virtual office. And so this allows for some things to be there. Now, with that being said, some of them, like Zillow, have a Zestimate, an automated estimate of market value. Now, line 72 and 74, line 72 says that the seller does not authorize an estimated value to be an automatic estimated value like a Zestimate to be on the listing. In what case would we not want to have an automated estimate of the market value? A live question. Yeah, I mean, it would be when the property or the estimated value is less than what we are putting the home on the market for, because the potential buyer is going to look at that and think, well, they're overpriced. Now, you might want to put one on there if it shows that our price is less than what the Zestimate is. Remember that People say that they understand that an automated estimate of the market value is just an estimate, and yet we have a lot of people who think that it's just solid, that they're seeing that Zestimate or they're seeing that estimated value online. So you can check this box. Also, line 74, seller does not authorize third parties to write comments or reviews about the listing of the property. So I personally, depending on the situation, check both of these boxes because there are trolls on the internet. There are people who are going to comment more often than not. If someone's commenting on the property, they're probably doing it because they don't have something nice to say. If they were interested, they would probably call me as the agent to ask more information. But the gentleman who hasn't purchased a home since 1968, who lives in West Virginia and is looking at home prices in Florida and says, I thought that homes in Florida were reasonable. I can't believe that someone would pay $350,000 for this piece of crap, is not a type of comment that I particularly would like on my listing. So I just make sure that I check that box, right? Yvette did bring up a good point. So it seems that I am using an older version of the listing agreement. And so the MLS has some new information about the MLS in the newer one. To be honest with you, I grabbed this. This is a 2017 listing agreement. Now that I'm looking at it, I grabbed this one from our forms drawer in the office. So please always make sure that you're going into DocuSign and you're looking at the Florida Interactive Forms to make sure that you have the most current version. Majority of these are going to be the same, so it doesn't fall on deaf ears or it's not a waste of time to be here through this process. Just understand what that looks like. Okay. Paragraph 7 is just talking about seller obligations. So we're just going to read through this quickly. They're going to cooperate with us in carrying out the purchase or the purpose of this agreement, including referring immediately to the broker all inquiries regarding the property's transfer, whether by purchase or any other means. They're going to provide the broker with keys of the property to make the property available for showings at reasonable times. They're going to inform us about any leasing, mortgaging, or otherwise encumbering issues that would happen about the property. It's to hold us harmless if anything happens during the process. So you'll see that it says they're going to hold you harmless from liability if anything happens, like the seller's negligence, representations, misrepresentations, actions, or inactions, the use of a lockbox, the existence of undisclosed material facts about the property, or a court or arbitration decision that a broker who was not compensated in connection with the transaction is entitled to compensation from the broker. So it's letting people know that they're going to hold the broker harmless if there are certain things that we just didn't have control over because of the seller. So this is a really great time to disclose any and all information that you know. If something happens after today, so let's say that we have a really bad storm this weekend and all of a sudden you discover a leak, that's something that I need to know. Even though it's happened after this paperwork has been signed and I have a fully executed seller's property disclosure, I still need that information, right? The seller is also going to perform any act that's reasonably necessary to comply with FIRPTA, right? So FIRPTA is in the case of where the individual is a foreign investor, and it's to make sure that they are actually doing the tax holdings so that, you know, Uncle Sam gets their cut. So that's just abiding by FIRPTA. You should know, or that's a great time to ask, do you live in Canada? Do you live somewhere else? Where does that information look like to where we would have to speak to title to make sure that we are just abiding by the FIRPTA rules? And then of course, line 89 is just making all legally required disclosures, including all facts that materially affect the property's value and are not readily observable or known by the buyer. So someone would say, well, the seller's property disclosure is not a required document. That is correct. What is required is that the seller must disclose any and all known facts about the property, and the seller's property disclosure is just a really great, concise way for them to go through and try to remember and then disclose any information that they might know. So we want to do that. Seller will immediately inform broker if anything happens after the signing of this agreement. I've already kind of spoken to that. And then they're going to consult with appropriate professionals for related legal, tax, property condition, environmental, foreign reporting requirements, and any other specialized advice. Remember that you are the source of the source. One of the best advices that I was ever, a bit of advice that I was ever given, sorry, the afternoon, my brain's shutting down, was to stay in my lane. And I'm going to say the same thing to you. Stay in your lane. If you are a licensed sales associate and that is it, if you are a licensed broker associate and that is it, then stay in your lane in helping with the sale of the property. If you are not a GC, do not speak to GC stuff. If you're not an electrician, do not speak on electrical stuff. If you are not a pool repair person, do not speak about what it's going to take to repair the pool. Always make sure that you are just going to direct them to the source so that they can consult and get the appropriate information. That also helps you from a liability standpoint, that you're not overstepping your bounds to making sure that they have the information that they need. Okay, paragraph 8 says compensation. So the seller will compensate the broker as specified below for procuring a buyer who is ready, willing, and able to purchase the property or any interest in the property on the terms of this agreement or on any other terms acceptable to seller. So this is where a lot of people ask this question. So do I put the full compensation or do I just put my side of the compensation? So everything from paragraph 8 to paragraph 9 basically is a subtraction equation. So whatever that amount is, if you charge 6% for your commission, then it would be 6% would be put there in line 99. Now, if your intention is for the total purchase and then plus any additional fee, so if there is an additional cost that you are passing on to the seller, whether it's part of your cost for transaction management or part of your cost for marketing or anything like that, then that would be that first section of A. Or if it is a flat fee commission that you've agreed to, then you would put the dollar amount that was agreed to on line 99 where the dollar sign is, right? And so in some instances, some people do sign a flat commission agreement where it doesn't matter what the home sells for, this is what they're going to get paid. More often than not, in our case, you can find either of those. Again, I have to be very careful about what I say on Facebook Live because I am talking to more than just our brokerage. So if you're curious about what you should put for commission, Yvette, I'll call you after. Everybody else, talk to your broker to know what that looks like. Line 102 is if they are considering doing an option, right? Like, so the seller is doing potentially owner financing, or they're doing like a rent to own or lease to own option, then there would be a certain commission that would be outlined on line 102. And then on line 105 is where you would answer if there's any kind of lease. So this is a great conversation to have. Most people, when they have their listing agreement done, they do paragraph 8 and they do subsection A on line 99. And then they don't fill anything out on 102 and they don't fill anything out on 105. And then the seller didn't get to sell the home the way that they wanted to. And so they're just thinking about renting it back out. Well, you can have that conversation, you know, Mr. and Mrs. Seller, if we don't sell your house, what are you going to do? Oh, well, I'll just put tenants in it. Okay, well, let me go ahead and let you know what that looks like. If by chance, because our intention is to sell, but if by chance we are going to list the home for lease and we actually are able to help you procure a tenant, then this is the amount that I would be paid, or this is the commission that would be put there, right? Line 108 says that the broker's fee is due in the following circumstances. If any interest in the property is transferred, whether by sale, lease, exchange, governmental action, bankruptcy, or any other means of transfer, regardless of whether the price or terms stated or the buyer is secured by seller, broker, or any other person, right? So reading that back through, or any other means of transfer, regardless of whether the buyer is secured by seller, broker, or any other person. So I've had listings where the person who is listing the property, after we signed the listing agreement, the very next day, a neighbor came by and knocked on the door, saw that they were doing some things in the house, asked them if they were selling. Seller said yes. The buyer was very interested, and then the seller comes back and says, well, I'm the one who found the buyer. They're the ones that knocked on my door. You didn't even do anything. Then this, of course, is where it says that it doesn't matter after this has been signed, that the broker is owed their commission, regardless of whether the buyer is secured by the seller, broker, or any other person. Or two, if the seller refuses or fails to sign an offer at the price and terms stated in this agreement and defaults on an executed sales contract, that would be in that case. And then also here is the termination date, the protection period that is on line 112. It says, if within blank days after the termination date, seller, broker, or any other licensed professional has communicated regarding the property during termination time. So understanding that this is where you have an opportunity where you can say, if within 90 days, within the termination date, or 180 days, whatever it looks like, again, go back to what is the market, how long are people typically in the market in your particular price point, where your efforts could have procured the buyer. You'll be able to also have a conversation about still being owed that compensation. However, look at line 115. It says, however, no fee will be due to broker if the property is relisted after termination date and sold through another broker. So this is really only in the instance where, let's say that a seller ends up talking to someone who wants to buy the house, and since they've already talked to one another, the seller says, well, I'm going to fire my agent. If you don't use an agent and it's just the two of us, and we can save on that commission, then I'll give you a deal on the sale of the home since we won't use any real estate agents. If that's the case, but you as a real estate professional were the one to procure the buyer, then you are still owed your compensation. Now, if someone else, another broker, comes in and relists the property, markets it, and gets it under contract, then like the line says on 115, then no fee will be due to broker in that instance. Line 117 talks about retained deposits. So as consideration for broker services, the broker is entitled to receive blank % of all deposits that seller retains as liquidated damages for a buyer's default in a transaction not to exceed the paragraph 8A fee, which was the amount of compensation. With this being said, I'm not your broker, but I'm going to tell you that I put 0 here. Right, on line 117, I put 0 because, first of all, as a licensed professional, sales professional, I get paid when we sell your home. Now, you're the one that has a mortgage payment. You're the one that incurred that debt. The deal fell through, so you still have carrying costs for your property. That deposit is yours as the seller. That's not mine. I will continue to work. We'll find another buyer. We'll get it sold. That's when I get paid. Number one. Number two is also if there is any dispute on any kind of escrow and you're entitled to 50% of the escrow, you will now be named in the lawsuit. So you will be sued because you are entitled to a part of that escrow. That's also why I put 0 there, so that I'm not hung up on the $3,000 escrow deposit on a particular property, right? So I put 0 for line 117. I do not leave it blank. Line 120, paragraph 9, and I know that we're getting kind of close here, and I want to be respectful of your time, so I just want to answer paragraph 9 and paragraph 11, and you can kind of go through the rest of it yourself. Paragraph 9, this is the amount that would be paid to the cooperating broker. So from paragraph 8, that was, let's just say 6%, and you want to give half of that to the other broker if they bring a buyer. Then on line 123, you would, in this place, you would put the 3% there. And you'll see that there are 3 different options, whether they are a single agent, a transaction broker, or there is a no brokerage relationship. You can have either a set dollar amount, or you can have that the number that is there. I will say something to this point, and again, I'm trying to be very careful because I'm on Facebook Live and we can't be talking about commissions and what we do with other people. If by chance you see that there is that what is known as the MLS fee, so if you go on the MLS and you see that it is 3% minus $295 or 3% minus $395, whatever it might be, if you intend to do that, if you intend to recoup a portion of that cost and you intend to pass that cost along to the agent on the other side, that must be in this document. So if you have 3% and your intention on the MLS is to put 3% minus 295, then on line 123 in that little area right next to the percentage, you would need to put 3% minus and then the dollar amount. You don't get to make that up. This is not your money. Remember, this is the seller's money, so you have to be very forthcoming about what that looks like. So that's paragraph 9 very quickly. I've already explained paragraph 10, talking about being a transaction broker. Paragraph 11 talks about conditional termination. So at the seller's request, the broker may agree to conditionally terminate the agreement. If that's the case, then they agree to also reimburse the broker for any expenses incurred, including marketing and some of the other things that are here, and to pay a cancellation fee of blank. In my experience, I have put a cancellation fee here. I put the cancellation fee depending on the price of the home. Let's just say I'm going to put the cancellation of $500 because then I don't have to necessarily itemize some of the other things. And I do this also so that there's some skin in the game. We don't really have this problem too often anymore. But what used to happen is people would want to test the waters. So you paid for photography, you paid for videography, you put a sign in the yard, and we go live on Thursday, we have open houses on the weekend, and they did not get the attention or the love that they thought that they were going to get over the weekend. They just thought their home was the best thing ever. They don't get any real traction in the first weekend, so they say, we want to take it off the market. It's clearly not a good time to sell. In that instance, that's when we have a really big problem because I've now paid all of that money to get the home ready for marketing, and I don't even have an opportunity to market the home. So I actually, in paragraph 11, I do put a cancellation fee, and with that, in the additional terms on the last page here, that's where I will specify that I will waive that cancellation fee after, say, 90 days, which gave me at least 3 months to market the home and do what I needed to do from that perspective, and not necessarily lose money. I've been able to squeeze the juice out of it, if you will. The rest of it, you should be able to read, right? Because it's all straightforward. You do not need the seller's social security number. You don't need any of that stuff. You basically need the seller's name and date, your signature and date. If you are doing this electronically through DocuSign, as soon as it's executed, they will have a copy. If you're doing it by hand, then you want to copy and then return to seller, so you'd actually put what that looks like. And you do need initials on all of the pages, okay? I know that was very quick, especially for the last half that's there, but do you have any questions that were not answered that I can answer legally in front of other people? Or do you have any ahas for me? You know, give me 2, 3 ahas, something that you found helpful from this, and then we will be out of here. Go ahead and put that in the chat box for me, please. Okay, so Georgia said waiving the fees for 90 days. She really liked that. If doing on DocuSign, do you initial and sign prior to seller? No, thank you for saying that. So as soon as all parties have signed, that becomes the effective date. I, as a control freak, like to have control of that. So I am always the last person to sign an initial, because then my wheels start turning. I start working as soon as I sign this off and it's executed. So I'm always the last person to sign. Thank you for asking that, Kelly. Anything else? Question or aha for me? All right, well, thank you all very much. I hope that this was helpful for you and is able to give you a little bit more understanding about the listing agreement. If you have any questions, please let me know. I bet I'll get with you offline about that compensation aspect. And of course, always be here every Thursday at 1 o'clock, or rather at noon, for our masterminds that we're doing, these kind of fundamental classes that go through the main things that are going to help you, the big pillars of your business, so that you feel comfortable and confident so that you can go take more business. Thank you all very much. I'll talk to you soon. Bye-bye.